Everyone at the court was greatly saddened to learn that our former colleague, Lord Clarke of Stone-cum-Ebony, passed away peacefully on Thursday of last week at the age of 82. Lord Clarke was one of the original justices of this court and its first member not to have sat in the Appellate Committee of the House of Lords. He served on the court from the day it opened in 2009 until his retirement in 2017. He had a very distinguished legal career before joining the Supreme Court, serving as Master of the Rolls and Head of Civil Justice in England and Wales. Before that, he had a very successful career at the bar and on the bench, particularly in the fields of commercial and maritime law. He was probably best known to the public as the judge who led the inquiry into the Marchioness disaster. As a judge, he combined a quick intelligence and great assurance with the common sense for which he was famous. Some of his judgments, such as Rainy Sky on the interpretation of contracts and Auto Cleanse on employment relationships, will long be cited. But those of us who worked with Tony will remember him primarily as a wonderful colleague, the kindest of men, with great humanity, a sense of humour, and a gift for friendship. In a lecture, he said, "I like to think that a happy judge is a good judge," and he put that belief into practice. He was described by Lord Neuberger at the joint valedictory as the genial and intelligent glue which had ensured the cohesion of the court. His life is well reflected in his coat of arms. The motto, Festina Lente, meaning make haste slowly, was characteristic of him. The escutcheon included the emblem of the Cinque Ports, reflecting the great pleasure he had taken in his appointment to the ancient post of Admiralty Judge of the Cinque Ports. The crest emerged from rosemary foliage in a tribute to his wife, Rosemary, to whom he was married for 58 years and to whom he was devoted. Our thoughts are with Lady Clarke and their children and grandchildren, to whom we send our condolences.
The King against McCafferty and others.
Yes, Mr. Newton.
Yes, thank you, my lord. My lords, my lady, I appear along with my learned friends, Stockdale, who represents Mr. McCafferty at trial, and Miss Lydiard, who represents Mr. Dixon at trial. We now all represent all 6 of the appellants in this matter, the other 4 appellants having represented themselves in the Crown Court. My learned friends, Mr. Perry, King's Counsel, Miss Ailes and Miss Hughes appear for the respondent. The certified question in this case is one that relates very specifically to private premises. And I'll read it at this stage because I'm going to start by going straight to the nub of it, if I may. Are persons who go to private business premises, whether as employees, customers, suppliers, or for some other reason connected with the business, a section of the public exercising or enjoying a right which may be exercised or enjoyed by the public at large within the meaning of section 78(1)(b)(2) of the PCSCA 2022, when they A, approach, B, enter, and or C, leave the premises. I go straight to the wording because in our submission, the certified question, within the question itself, identifies the very limited persons who may exercise or enjoy the right to go to private business premises. At the outset of the question, it asks about persons who go to private business premises and then specifies employees, customers, suppliers, or for some other reason connected with the business. Now, clearly, employees, customers, and suppliers are all connected with the business. So, in essence, the question is whether persons connected with the business who go to private business premises are exercising or enjoying a right which may be exercised or enjoyed by the public at large. And so we say right at the outset that almost tautologiously the answer is no, because clearly it's been limited to people who have some purpose or some reason connected with the business. In relation to private business premises, they have to be recognised as being distinct from private premises that are open to the public and more akin to private residential premises than public-facing commercial premises, such as a shopping centre. And so if we look at examples from the case law in relation to public nuisance, we have cases such as the most recent case on the Section 78 offence, Smith, which related to a privately owned racecourse, but one that was open to the public on race day. There's the case of Ong that relates to a Liverpool-Charlton football match, so again on private premises, but open. But
none of these were about this section of the offence that we're concerned with, were they? Those cases were cases about, the first, what is now serious harm, as it's put in the statute. It was less than that before.
Yes.
They weren't cases about the question, which is the only question raised on this appeal, which is what is the nature of a public right, in effect?
No, I respectfully agree, my Lord, but the distinction we just seek to draw, and I don't think it's terribly controversial, is that there will be circumstances in which the law makes it clear that private premises may nonetheless come within the scope of public nuisance. It's a point that the Court of Appeal made in their principles. It's something that we've never taken issue with. Clearly, a public nuisance can arise in circumstances with private
Clearly property. A public nuisance can, but we're interested in whether the rights are public or not.
Yes. Well, we would submit that there are public rights in relation to that same category of case where you have, let's take an example, a large music festival. And it's entirely possible that a large music festival taking place on private land, where for 51 weeks of the year it's private farmland, but for 1 week of the year it's made open to the public to attend a music festival. Clearly, during that 1 week of the year, an obstruction of the rights of the public... You say
clearly, but why are you making that submission? I mean, you might as well not come along to argue this appeal, if that's your case. If you're saying that the private road that there's a public right to go along the private road, then you might as well not have appealed, because your clients were sitting in the middle of the private road.
Well, we do say that a private road is distinguishable, because the situation we're dealing with is when, or that I'm seeking to outline, is one where private premises effectively become somewhere that the public may go for a specified period of time or a specified purpose, such as a football stadium for a football match. So in essence, obstructing members of the public from attending Wembley Stadium on the day of an England international football match would be obstructing the public in the exercise of a right that they have, which would be to go and see their national team play a football match at the national stadium. But the case we're dealing with here doesn't engage that situation, because we're not dealing with private premises in any sense that could be regarded as being publicly facing or open to the public. And so we seek to draw a distinction, which we say is plain on the authorities in any event, between truly private premises, i.e. premises where the public simply have no right to go, and private premises such as Aintree Racecourse or somewhere of that nature, where the public will at times have a right to go. And
do they? The owners of the racecourse could decide that they don't want to admit somebody, couldn't they?
Well, my law's absolutely...
If they caused a nuisance in the past or something like that, they'd say, we're not allowing you to come to the racecourse.
If you go to a football match or a cricket match or whatever, you don't just walk in. You're faced by barriers and people who want to inspect your bags, check you don't have alcohol on you, make sure you're in the right part of the ground if it's allocated to different supporters. It's not like walking across Parliament Square from here to the House of Parliament.
Mm. Yes, well, again, the case law does make clear that a public right doesn't have to be an unfettered right, and so in circumstances where there are controls, such as bag searches and so on and so forth.
Where does the case law make this clear?
Forgive me.
Because one thing I've failed to see in the cases I've looked at is any case that draws the distinction that you seem happy to make.
But even if a public right can be fettered in the sense of there are certain times where the public can go, and other, say a public park but that closes
Yes.
during the evening, that doesn't alter the fact that it's a public the public can go when it's open.
Yes.
But that doesn't make it, that it's still a public right. And what you're suggesting is that a private permission to access a private road becomes a public right.
If the landowner chooses to grant it to everybody rather than to everybody except for two people.
That's the bit that's difficult at the moment.
Yes. No, I understand. Well, it may be, being clear about it, that the concession that I offer is one that if the court is not minded to accept, simply goes in our favour in any event. And so I'm not minded to push the argument particularly. I think it's an argument that the respondents may seek to make. But
yes. Yes, I'm sure it is.
Yes.
That's why we're slightly surprised that you're making it. Are you able to answer His Lordship's question as to whether there's any authority to support the concession you're making?
And I think there are two things that have been raised. One is authority to support the concession you're making, but the particular point you made was that the cases make it clear that a public right does not have to be an unfettered right. So if you could help us if there's authority on that as well, that would be useful.
I'm so sorry, my lord. Could I ask again?
You said the cases are clear, a public right does not have to be an unfettered right. And that was when my Lord Legate asked his question, well, what cases are these? All I'm doing is pointing out, if you could help us with those cases, that would be useful.
Yes.
But also, you've now been asked, is there a case that supports your concession? Those two things may not be identical. So if you're able to help us with either of them, that would be most welcome.
No, I follow. My lord, I wonder if it would be acceptable if I allow my juniors to continue to work on that while I move to a different point, or we can pause while I try and deal with it.
No, it sounds as if we'd better make progress, and your junior can try to find if there's any authority that supports the argument.
Yes, thank you.
You seem to have given up on this point somewhere between the Crown Court and the Court of Appeal, because on page 65, in paragraph 8 of your submissions to the judge, you were making the point to say that the public at large does not have a right to travel along Poynton Way because it's a private road.
Yes, if I may, my lord, I'm going to come to what's described as being the concession we make in well, I'll come to it now, in fact. As my lords and my lady could see, at paragraph 8 of his Honour Judge Jackson's ruling, where he summarised defence submissions at page 65, that's also the position that was taken in the lower court, and he specifically identifies in relation to the defence submissions at paragraph 8 that it was put quite succinctly as Poynton Way is a private road. The public at large does not have a right to travel along it to gain access to or exit on the Muller site. And my lord's, of course, correct that that is what was argued in our submissions. At paragraph 28 of our case, we're actually dealing with the co-defendant Daniel Juniper, and what essentially happened, where the Court of Appeal at paragraph 26 of their judgment refer to it being realistically accepted on behalf of the defendants that although it is a private road, the general public have a right to pass along it. That was, in essence, something that was perceived as being a moot point at that stage, because for reasons I'll come back to in a moment, the way the Crown's case was put at trial was such that it wasn't being alleged that the obstruction was an obstruction to Poynton Way or to move along Poynton Way. And there is a clear distinction to be drawn between counts 1 and 2 on the trial indictment, because the allegation in relation to these 6 appellants is that they were obstructing entrance and egress from Muller, not that they were obstructing Poynton Way, in direct contrast to count 2, which obstructed the flow of traffic along Poynton Way in relation to Daniel Juniper. Now, Mr. Juniper wasn't...
I couldn't understand paragraph 28, because you say that in the other case, the action took place on the private road through the business park. And according to the pictures I've seen, that's exactly where the action in this case took place, on the private road.
Yes.
So are we to sort of imagine some part of the private road that's public and some treated as public and some part that's treated as truly private? Where on the private road does that line appear?
I think the position, my lord, is that it
depends how close you are to the entrance?
We maintain the position originally advanced in the submission no case to answer and as acknowledged by His Honour Judge Jackson in the lower court that Poynton Way is a private road and there is no right of access along it. The concession that was made in the Court of Appeal was made in the context of what appeared at that stage to be a moot point because it was not the Crown's case in the lower court that these 6 appellants had obstructed Poynton Way. The Crown's case in the lower court had been that these 6 appellants obstructed access to the Muller site. And so at that point, it wasn't something that appeared to be pertinent to the case against these 6 appellants. The way the Court of Appeal have then framed it in their judgment, I will freely confess it probably took us a moment to catch up with in terms of responding to the respondent's case. It's been very helpful to have the benefit of the respondent's written case and the authorities they rely on to bring this into focus, because this is not the way that the Crown put the case in the Crown Courts. The position, just to reiterate, that we take is that the general public's use of a private road has to be seen in the context of the right they're actually exercising. And so we would say that obstruction of a private road cannot in and of itself amount to public nuisance if the general public do not have a right to pass along the road. Now, whether there could be circumstances in which an act takes place on a private road that amounts to the obstruction of a right enjoyed by the public might be a different matter if there were circumstances where the obstruction on a road that had been temporarily open to give access might prevent the public enjoying some other ancillary right. But we would say that the obstruction of a private road, and particularly one such as Poynton Way, where it's clearly signposted to the contrary, would not give rise to a public nuisance. And so that's the position we take.
And that's because the public are not exercising a public right.
Exactly.
They're exercising a private right.
Exactly. So those members of the public who have a right to travel along Poynton Way are quite clearly analogous to those, not identical, but analogous to those who have a right to enter the Muller site. It would be people who have...
I'm not sure that anybody has a right to travel along Poynton Way or enter the Muller site. They're granted permission by the owners. Maybe a permission granted to everybody, or it may be a permission granted to only certain people. But it's not a matter of right, is it? If the owner said, no, I have decided I don't want to admit you, you wouldn't have a right.
No, I entirely agree, my lords. If one phrases it as a permission rather than the right, it's a permission that can be withdrawn at any time.
And for avoidance of doubt, at the end of paragraph 28, you refer to a right of way along the private road, but as I understand it, there is no right of way.
No, there's no right of way. I do apologise for the ambiguity. As I say, there is definitely a sense in this case, which I am keen to come to in a moment, as to the movement of the key issue in the case from the way it was argued in the Crown Court and the way the case was...
There was a bridle way, I think, and that is, I think, a bridle way is something you do have a right to use for pedestrians and for horses. I think that's the point of a bridle way, isn't it?
Yes, the protesters came down a bridle way.
Yes,
that
so
runs
at that point,
yes.
They were exercising a public right.
Yes, but not at the point where they're committing the obstruction and arrested. No, that's entirely right, my lord.
Is the bridle way part of Poynton?
It goes alongside, I think.
Parallel.
No, it's not part of it.
It's parallel to it.
It's a separate. It's effectively a country lane and, in effect, a country footpath. It's not. Yeah. I don't think it's something that would be used by vehicles.
Yes. So there's no right of way along Poynton, whatever it is,
no.
road or way.
No. And so we would submit that the Court of Appeal's own position at paragraph 26 sets out the factual basis for this anyway, that the production site is situated on an estate, the common parts of which, including the road which leads to the production site and other industrial premises, are owned by an investment company. There is at least one sign stating that the road is a private road. That road, however, provides access to a number of different businesses and to a bridle way which runs along one side of the production site. The respondents on this point in relation to the character of a private road rely on the case of Bowen, which is a extremely thorough civil judgment, but really relates entirely to the application of road traffic law to private roads and circumstances in which a road might be considered to be a road for the purposes of, for instance, the Road Traffic Act 1988. And we would submit that it's an entirely different issue in terms of whether or not a road could be considered to be a road for the purposes of, for instance, driving while under the influence of alcohol, compared to a situation where one's dealing with public and private rights in terms of public nuisance. So our position in relation to Bowen is that it's interesting but of limited assistance in these circumstances. And we would draw a contrast with the cases of Hallam and Troland and Decker, two recent public nuisance cases which obviously relate to the M25 motorway, one on the north stretch and one on the Dartford crossing. And so our position again is that the point of way is not a right of way. Unless I can further on that point, I'll move on.
Let me just ask you about the motorway example. The toll section of the M6,
yes.
is that a public right of way?
I'll be honest, my lord, I don't know if that's privately owned or if it's owned by the Highways Agency. If it's privately owned, then an issue could arise in relation to it.
And can you explain, looking at section 78(1)(b)(2), which is on page 222, the test is obstructs the public or a section of the public in the exercise or enjoyment of a right that may be exercised or enjoyed by the public at large. If the private landowner who owns a private road gives general permission to the public to pass over that road, why do you say that is not a right that may be exercised or enjoyed by the public at large?
Well, one answer to that would be returning to the principle we touched upon a moment ago, which is that that would be a right that could be revoked at any time.
But why isn't it a right pro tem? Well, it hasn't been revoked.
If it is possible for a right over private land to be created for a specific period of time by the owner of the land by granting a permission, and if that does amount to a right, then in those circumstances it would be possible under certain circumstances for the use of a road to be interpreted as a public right if the owners of the road were to make that the position. And really, I become somewhat circular here because I fall back on my original example of a music festival where one could say that a private lane leading to a music festival, if one works on the basis that access to that music festival could be regarded as a public right, then clearly the right of access given to the road leading to the music festival could be something that could be interpreted as a public right. But really the two seem to rise and fall together in that it depends whether or not rights can be temporarily granted.
Yes, thank you.
Now, I've mentioned a couple of times the Court of Appeal's principles and the issue that we were specifically invited by the court to address in terms of whether or not the licence granted by the owner of a privately owned road to pass along it is a right, effectively engages the second principle that the Court of Appeal identified, and we've set out our position on that. We don't take any issue in relation to the first and third principles, but the respondents in their written case did raise the issue as to what the appellant's position was across the five principles. And so just to be absolutely clear on this, the fourth and fifth principles that the Court of Appeal outlined were the subject of two further questions that we applied to the Court of Appeal to certify. Neither was certified, which is why they're not dealt with in any detail. But we do address the difficulties that these principles would give rise to in our written case at paragraphs 34 to 40. Our argument being that the Court of Appeal's ruling has left the law unclear and uncertain, and the statutory offence so broad that it need not involve any disruption to the public. And so in relation to the fourth principle that the Court of Appeal set out, that the offence does not require proof of an obstruction which wholly prevents the exercise or enjoyment of a public right, and that it's sufficient that it's made more difficult or less convenient, our argument on that point is that the obstruction, we would say, would need to be more than de minimis, and to say that anything that makes the enjoyment of a right more difficult or less convenient without any kind of threshold test would be to cast the net too wide.
Well, we're not in that territory here, are we? Sticking
No.
yourself to the road for 4 hours is more than just de minimis.
No, can I say I respectfully agree, my lords, and it's the same in relation to the fifth principle. We can seek to assist the court with our position on it, but it doesn't directly impinge on the facts of this case. I respectfully agree. In relation to the fifth principle, just dealing with it very, very swiftly, which is that the offence may still be committed even if no member of the public actually attempted to exercise the right obstructed. So in effect, a hypothetical obstruction where a right would be obstructed if someone tried to exercise it, but in fact nobody has. An example could be infringement on a race day of a racetrack, an infringement of a racetrack on a day when there's no racing. We would say that an obstruction mustn't be hypothetical, it must be actual, and that the language of section 78(1)(b)(2) states that the person's act or omission obstructs the public or a section of the public, not that it's capable of obstructing. But again, I'll move on because I appreciate these aren't the issues that the court's primarily concerned with in this case. I've mentioned the movement of the Crown's case at trial to where we now are on this appeal, and I think it's important just to be clear on that because it has particular relevance in relation to our 6 clients and the way that their case has developed. And I hope it's clear to the court from the indictment that we find at page 69 of the bundle that the way the case was indicted against these 6 appellants, the act was preventing access to an egress from the Muller UK production site. There's nothing in the particulars of the offence that suggests that any obstruction of point and way was any part of the offence that they were accused of. And in the opening notes that the Crown served on the first page, it makes clear these defendants are all involved in attaching themselves to fencing on the ground and obstructing access to the Muller dairy for approximately 4 hours, causing a public nuisance. And it's quite clear that what the Crown intend there is that the obstruction of access to the Muller dairy for 4 hours is the public nuisance. And they go on later in their opening note where they deal with event D. This is page 74 of the bundle. They say these defendants carried on down a bridle path at the side of the Muller site and went to the temporary fencing placed at the entrance designed to assist in securing the site. And on that point, it's important to note that it was in fact Muller who had already obstructed the public's access to their entrance with the Harris fences. And we can see on the storyboard, this is page 147 of the bundle, we can see where the offences had been preemptorily erected that morning.
Sorry, what page?
Page 147, my lady. Sorry. We can see there on the storyboard that Muller had already erected fences in Point and Way beyond the curtilage of their own private property that had already restricted the public's access to the gateway. And the protest that takes place is, in essence, the appellants coming to those fences that were already in place across that corner of Point and Way and impeding the ability of Muller staff to re-separate the fences, such as to control access to the Muller site through those fences.
Those are the appellants, are they, sitting on the ground there?
Yes, that's right, my lord. And so what we have, and it's set out throughout these storyboards, is a situation where 5 of the 6 appellants were directly attached to these fences, which had already been put in place before they arrived. And the 6th appellant, Catherine Cannon, glued to the tarmac just in front of one of the fences. But 5 of them, as I say, attached to the fences. But to the extent that they're said to be obstructing Point and Way, it does beg the question of the fact that those fences were already there before they arrived. It's clear from Anthony Bates' statement in support of...
Well, they're clearly obstructing Point and Way because they're stopping people passing from otherwise being able to open the fence and go through it.
Yes. in respect of the respondent's case of the public having a right to actually approach the gateway itself and the barriers to seek entrance, we would observe that the public's ability to pass across that final part of Point and Way to the barriers to seek entrance is already being obstructed, because presumably they would be told at the barriers whether or not they could come any further. Those people operating the barriers are not going to let anyone and everyone come through, so they can then ask the question.
But they're a section of the public, aren't they?
Forgive me, my lord?
They are a section of the public.
But in terms of the respondent's case, that the public at large have a right to approach the manned barriers at the Muller site to seek entrance, the scenario that we're dealing with on the facts of this case is one where the public are not able to approach the Muller barriers to seek entrance, because in essence, anyone trying to get into the site is already being vetted at the barriers before they can come any further. And so the appellants in this case are not actually preventing anyone who does not have any reason to be on the site from getting any further than they'd be able to get anyway. They're already restricted at that point by the barriers that Muller have erected. So this hypothetical scenario of the appellants preventing members of the public seeking entrance, irrespective of whether they're entitled to it, really doesn't arise on the facts of this case, because it's already been done by Muller.
Well, Muller are controlling who's going past the barriers.
Yes.
That's not obstructing those who they let in.
No, I'm not suggesting for a second that Muller are committing any offence, because, of course, one can assume that they would have, or at least be able to imply the permission of the owner of Point and Way to be able to do what they're doing in the circumstances they are. But it doesn't change the fact that on this particular day, members of the public seeking to gain entry to Muller would have to seek to gain entry, if they were to do it face-to-face, at the barriers that have been erected rather than at the gatehouse. And therefore, these 6 appellants haven't prevented them getting any further than they would have been able to get anyway, even if this protest hadn't taken place, because the barriers had already become the de facto perimeter of the Muller premises.
Because they've stopped the barriers being opened.
Oh, that's right. They've prevented people moving through the barriers to the extent that those people who have business on the site are able to come and go. That's absolutely right. So in relation to the section of the public who have a right to enter or leave Muller, there is an obstruction in place in relation to that section of the public who have a right to be there. But the respondent's case is based on the idea that the public at large have a right to at least seek entrance to Muller, irrespective of whether or not they're permitted entrance. And so the point we make is that on this occasion, the point at which they would be able to seek entrance and potentially be turned away is exactly the same, irrespective of this protest taking place, because it's not the appellants who erected those barriers, it's Muller.
Well, but the barriers can be opened.
Yes.
And that is what, presumably, the right-hand side image is the public or the cars being allowed through when the barriers open. But the appellants were blocking opening of the barriers by attaching themselves to the barriers or gluing themselves to the tarmac. So I just don't understand your point.
No, forgive me, my lady. It's to do with the distinction between seeking access to the Muller site and gaining access to the Muller site.
Yes.
So we don't dispute that the effect of the protest on the 8th of September was such as to obstruct access into the Muller site. And the issue that was litigated in the Crown Court was whether or not that access to the Muller site was a right that could be enjoyed or exercised by the public at large, and His Honour Judge Jackson found that it wasn't. The issue that has essentially arisen during the course of the appellate proceedings is whether or not there is in fact a right to approach the Muller gateway that is enjoyed by the public at large, and it's argued on behalf of the respondents that any member of the public, irrespective of whether they actually do have business in the Muller premises that day such that they would be admitted entry, any member of the public has the right to approach that gateway, to at least seek entry, even if they are then turned away. And so it's that new category, as I would put it, of the final approach, if you like, the final few yards across Poynton Way, which is what the respondents essentially now rely on as the obstruction. It's those last few yards across the tarmac before one gets to the curtilage of Muller. And the respondents are now arguing that it's the obstruction of the general public's right to cross those last few yards of tarmac to the point where they can seek entry at the gatehouse, which is the public nuisance. And we say that on the facts of this case, that can't arise because it's not the appellants who are actually preventing people from seeking entry at the gatehouse rather than seeking entry at the fence, because that's a system that's been deployed that morning by Muller of their own volition and would have been in application that day anyway. And so it relates to that point. We have other arguments as to why we say that's not a public nuisance in any event in terms of travelling across those last few yards of tarmac. But we say that on the facts of this case, even if the Crown are right in principle, on this case, the case could not have been argued in that way.
Are you making a point that the way it was put in the Court of Appeal by the Crown is something that was not permitted to them because of the way in which the indictment was framed?
I think the Crown put it in the same way in the Court of Appeal that they put it in the lower court. In fact, and I make no criticism of the respondents at all, but in essence, the Court of Appeal have seen this case in a different way, and the respondents now seek, perfectly appropriately, to defend the Court of Appeal's reasoning. But the way the case was put by the prosecution previously, and if we start with the prosecution submissions on the no case to answer, which are at page 212, we can see at page 212, the prosecution... Hold on. Forgive me, I'm so sorry.
Yes, you're going rather fast.
I'm so sorry, my lord. We can see at paragraph A, the Crown made the concession on the submission no case to answer that the prosecution cases that the named defendants obstructed access to and egress from the Muller site, and it is not asserted any other separate members of the public in any other area were affected for the purposes of count 1 on the 8th of September. So at that stage, the Crown are excluding anyone other than people who had business getting on and off the Muller site. It's only as a result of the Court of Appeal's judgment that we deal with an expanded submission that it could include members of the public who didn't have a right to go on or off the Muller site, but at the very least had a right to seek entry to the Muller site.
Right. Sorry, this document that you're showing us, this is a document at trial?
Yes, this is the prosecution's response to the submission of no case to answer.
Are you now saying that in the Court of Appeal, the Crown, again, did not argue for the analysis that the Court of Appeal came up with?
Well, if I may finish...
Because my question to you, I rather assumed that the Crown in the Court of Appeal were putting their case as they're putting it to us now. My question to you was, are you saying that that was not a permissible move by the Crown because of the way the indictment had been framed? That's how we got here. That's why I was asking my question.
Yes, no, I understand.
We're still waiting for the answer.
Yes, forgive me. In terms of whether it's a permissible approach or not, I think the difficulty is that we don't perceive it to have been the Crown who caused the Court of Appeal to interpret this case in a different way in their judgment. And we then find ourselves in a position on appeal where the Crown properly seek to defend the Court of Appeal's reasoning. But it is reasoning that was not based on their submissions in the first place.
But the question is whether it's permissible on the basis of the indictment.
Well, we would say that it is not possible at this stage for His Honour Judge Jackson's ruling to be found to have been wrong, going right back to the origin of this interlocutory appeal, on the basis of the way it's now being argued, because the argument and the principles have moved away from the facts in such a way that if we move back to the facts and we look at the actual facts and look at the way it was presented in the Crown Court, in fact, His Honour Judge Jackson's ruling stands up to scrutiny, notwithstanding the way that the respondents put their case now on appeal. And so, in essence, we've got something of a divide between the certified question, the issues of principle that we are seeking to assist the court with today, and the basic point as to whether or not His Honour Judge Jackson was wrong to find there was no case to answer. And so we're trying to ride both horses, essentially, and assist the court with the points of principle, whilst also drawing to this court's attention the fact that the goalposts have moved somewhat. And if we go back to the original position, His Honour Judge Jackson's ruling on the way the Crown put their case and the way the case was indicted does stand up to scrutiny and should not have been overturned by the Court of Appeal.
Can I ask, do we know how the Crown did put its case in the Court of Appeal?
Yes, so if we go, my Lord, to page 53 of the bundle, and we have at paragraph 10 of the Court of Appeal's judgment. In the present case, it is submitted for the prosecution that employees and legitimate visitors to the private premises were exercising a right that may be exercised or enjoyed by the public at large. That is so, it is submitted, even though the right of entry to the premises could be restricted by the owners. The legislation, it is argued, does not require the exercise by the public at large of an unfettered right.
Thank you.
And so what we have within the Court of Appeal's decision is a situation where from there, where they summarise the Crown's case being presented by trial counsel on the interlocutory appeal, and then the defence case in the following paragraph, where I note for completeness the second half of that paragraph, that the defence submitted the right in question must be one which belongs to all members of the public, even if only a section of the public may be obstructed in their exercise of that right. The public at large, it is submitted, do not have a right of access to private property. Employees and others authorised or permitted to enter and leave the premises concerned here, it is argued, were exercising private rights. And so that's where the battleground essentially was. But we then, at the end of the Court of Appeal's judgment, once they've made their 5 statements of principle and applied them to the facts of the case, we then get the paragraphs which are at page 59 onwards of the bundle, paragraphs 35 onwards, which the respondents now rely on, where the Court of Appeal effectively set out what we say is essentially a new prosecution case of sorts, which relates to the obstruction to point and way rather than the obstruction to the Muller premises, and introduces this issue that we're now dealing with as to that strip of tarmac that we see on those photographs between the barriers or at the barriers to the gatepost, which is essentially the part of point and way that on the Court of Appeal's logic and the respondent's case the obstruction now relates to, not Muller's premises, but the private property that is point and way in that strip. And going back to the point I was making a few moments ago, we make the observation that on the facts of the case, which by now have become somewhat lost, that strip of tarmac on point and way between the barriers and the gatepost had already been cut off from the general public's access by the Harris fences that Muller erected. And they've effectively enlarged their own boundary to the Harris fence line. So the fact that entry and egress from Muller is now taking place within point and way rather than on Muller's own property is simply a result of Muller extending their own boundary with the use of the Harris fencing into point and way.
But suppose that had been a public road, that would have been a clear nuisance, wouldn't it?
Well, it would have been a difficulty for Muller if they'd done that on a public road.
Well, it might have been a difficulty for them, but it still wouldn't have helped the appellants, would it? They would have been committing the offence, plainly. Or do you say otherwise? They stuck themselves on the public road and the fencing had been moved out there.
I would be reluctant to make that concession, my Lord, bearing in mind that the obstruction to that part of the road is already in place.
So if someone's caused an obstruction on the public highway, that entitles you, does it, to make it worse and cause an additional obstruction on the public highway?
No, but the issue that would be arising in practical terms, if Muller had done that with that being a public road but on the private road, would have been the issue as to whether or not those Harris fences should even have existed along that stretch.
I'm not asking you about that.
Yes.
I'm asking you whether it would have been a defence for your clients. And what's your answer to that?
It would be a strange scenario for them to effectively be acting in a joint enterprise with Muller, which is what they would effectively be doing if they were making worse an obstruction to the public highway that Muller had already created.
No, it wouldn't be a joint enterprise with Muller. It would just be creating an additional obstruction and a much worse one.
I fully accept, my lord, that it would be adding to the obstruction that was in place. But the point remains that what the appellants have actually done in this case is they've obstructed the point of access to Muller's headquarters.
Well, I know you keep making that point, but I'm trying to get at whether that's a relevant point or whether really the relevant point is the nature of the road and whether that makes a legal difference.
Our position in relation to the road is, as I've set out, that it does make a legal difference, and that the fact that this is a private road does change it from it being a public road. It's a point I'll come on to in a moment in terms of what the appellants were actually originally arrested for, and the fact that the majority of them were arrested initially for obstruction of the highway, but of course they couldn't be charged with obstruction of the highway because it's not a public highway. So
they could have been charged under the first limb of 78, couldn't they? Causing a serious inconvenience and annoyance, which you might have thought would have been satisfied in this case.
Forgive me, my lord, it'll take me a moment to process that.
Page 222.
Yes, thank you.
I'm looking at the definition of serious harm. It includes serious inconvenience. You would have thought it was a pretty serious inconvenience to be stuck on the site for 4 hours after your night shift has ended.
The difficulty, my lord, is that had that been the way that the Crown's case was put, and had the defendants been indicted under that subsection, then obviously the case would have been run in a different way from the outset. I take my lord's point that that's a way in which the Crown could have sought to put their case, but I'm not in a position to say what the defence would have been to that and what the submissions would have been in relation to that on the spur of the moment, I'm afraid. I think we would say that serious harm to the public, even in the case of serious inconvenience, isn't something that would arise on facts such as these, and that's something, again, that's probably more well illustrated by the examples we've already referred to in terms of Hallam, Troller and Decker.
Well, it would have been a question for the jury, wouldn't it?
Yes. At most, it would have been a question for the jury. Whether or not there would have been a case to answer is a different matter, but yes.
I might have thought that there would at the very least be a case to answer, but...
Yes, I take my lord's point. I suspect at the very least it would have been argued that the level of inconvenience caused in these circumstances would be such that it wouldn't amount to serious harm to the public or a section of the public when looked at on the facts. But I agree that that would have been a factual issue for a jury. I respectfully agree.
Can I just ask, you said a little while ago that the battleground in the Court of Appeal was between paragraphs 10 and 11, with the Crown saying that this was a public right that was being interfered with, and the defendants saying it was a private right. But I'm just looking at paragraph 26 of the Court of Appeal's judgment and wondering if that's why the Court of Appeal went in a different direction. Because in the last sentence it says that you had accepted on behalf of the defendants that although it was a private road, the public had a right to pass along it.
Yes. As I said, the concession that's been identified by the respondent that one finds there in that paragraph and where we make reference at paragraph 28 of our written case to the co-defendant's position, although it's not clear in this paragraph of the Court of Appeal's judgment, was in both circumstances in relation to the contrasting position of Count 2 and the co-defendant's position. And it's to the extent that there was ever any concession, it ought not to have been made because...
But I mean, did the Court of Appeal accurately reflect what you were saying? That the general public had a right to pass along point and when?
Forgive me, my lady, I'm not sure I understand the question.
Did the Court of Appeal accurately record what you were saying on behalf of the defendants, that the general public had a right to pass along Poynton Way?
If I may, my lady, because it was Miss Stockdale who dealt with this in the Court of Appeal.
I'm so sorry.
So as I say, this was a point where it's Miss Stockdale on her feet in the Court of Appeal dealing with it. Her recollection is that she said that it may have been that the public would have had a right, but it was in the context of what at that point was considered to be a somewhat moot point that didn't apply to the facts of this case, but applied to Mr. Juniper's situation on count 2 of the indictment rather than these 6 appellants on count 1. And so in essence, it was something that was not resisted at that stage in circumstances where it didn't seem to have any bearing on the way the case was being put against these 6 appellants.
I'm not absolutely clear why it didn't have any bearing. Are you saying that the appropriate focus was at the gatehouse?
Yes, as we've, I hope, shown through the Crown's opening note and the way their position's been recorded in the various judgments, the Crown's case at trial was always very squarely on the obstruction being an obstruction of entry into Muller rather than an obstruction of Poynton Way. And the distinction is there on count 2, where a case was being simultaneously run against Mr. Juniper in front of the same jury on obstruction of Poynton Way and the flow of traffic on Poynton Way. And so this distinction would have been far clearer in the context of the trial, where Mr. Juniper was also being tried and the Crown were putting the case against him on the basis of him having obstructed flow of traffic on Poynton Way, but were explicitly not putting the case against these 6 appellants on that basis. And so, in terms of the way that the Crown put their case at trial, we say that his on Judge Jackson's decision at page 67 of the bundle, where he reaches paragraphs 13 and 14 and sets out his conclusions, was entirely justified in relation to the nuisance, the public nuisance that was being alleged in that trial. And as we've seen, even in the Court of Appeal, the Crown didn't change their position specifically when they argued the case in the Court of Appeal. The Court of Appeal have interpreted the case in such a way as to effectively shift the issue as to whether or not there was an obstruction of Poynton Way rather than an obstruction of entry to Muller. And we seek now to deal with that issue and to seek to assist the court on the certified question, the point that was raised ahead of this hearing, whilst observing that in fact, when one goes back to the way that the case was presented at trial and the reasons that were put forward in terms of why his on Judge Jackson's ruling was incorrect, we would submit that, come what may, the Court of Appeal's decision in relation to these 6 appellants should be overturned and the appeal should be allowed in relation to them, whatever points of principle the court might find in relation to the issues that we're now dealing with. And in the...
But forgive me, I mean, how could we do that, given that that is not an issue raised for us on this appeal? Well, I can see that there may have been arguments at some stage earlier on, and that's what I was asking you about, whether the analysis by the Court of Appeal fell out with what was legitimate in terms of the way the indictment had been put. But But that's not an issue that's been raised for us on this appeal, is it?
We would say it is, my Lord. If I can clarify in this way, and I'm grateful for the opportunity to do so, if we look at the statements of facts and issues that the parties agreed ahead of this hearing and go to the last page, which is page 10 of the bundle, where we've set out the certified question at paragraph 28. And then the certified question having been set out, I'll accept now that the way that the ground of appeal was put forward, so paragraph 29, did reflect the way we had understood the case to have been argued in the lower court, and we have moved on in our approach to the case in the light of the respondent's very helpful written case and further consideration of the Court of Appeal's judgment. But the paragraph that I refer to is paragraph 30, where the parties have sought to set out the issues for this court to determine, and that the first is in essence simply the certified question. But the respondents, and we were entirely content with this, the respondents sought the second issue as to whether or not the trial judge was right or wrong to analyse the case on the basis that the right of access to and egress from the Muller UK production site was not a right that may be exercised by the public at large, and therefore that there was no evidence that a right exercised or enjoyed by the public at large had been infringed. And what that really goes to is this question of whether or not this case should be looked at the way the trial judge looked at it, or whether it should be looked at the way the Court of Appeal looked at it. And our position would be that the way the trial judge approached it reflected the way that the Crown put their case in the Crown Court. And so the trial judge was right to analyse the case in the way that he did, because when one looks at the indictment, the opening note, and the way the Crown have put their case even on the interlocutory appeal, it's quite clear that the trial judge was addressing the case the Crown sought to prove at that time. And so that's an issue that is raised. In terms of how it would interplay with the certified question, our position is very clearly that the certified question should be answered in the negative, because as I set out at the start of this hearing, we say that it's quite clear that persons who are connected with the business and go to a private business for reasons connected with the business are not exercising or enjoying rights held by the public at large. And so we say, in relation to the certified question, whether one looks at A, B, or C, the answer is still no, that no rights that are specifically identified to persons connected with private business premises are rights exercised or enjoyed by the public at large.
Well, they may or may not be. It depends what they're doing, doesn't it?
Well, we would say that there are no rights that exist solely within that cohort that could be said to...
Suppose it was a public road. Suppose it had been a public road. Then in approaching the premises, they would have been exercising a right enjoyed by the public at large, wouldn't they? They may have been going to the site for reasons connected with the business, as described, but they would have been exercising a public right in walking up to it if they were just using the public road.
We would submit that the question of approach to private premises as a means to effectively encapsulate the obstruction of, taking my Lord's example, a public highway, keeping it in those simple confines, is effectively conflating one obstruction with a different obstruction. Because, taking an example, if one has a gate, a front gate, a pedestrian gate off a pavement that leads to a pathway up to a terrace, the front door of a terraced house, if one were to stand across the pavement, obstructing people from moving along the pavement, then clearly there is a meaningful obstruction of the highway in terms of preventing people moving back and forth along that pavement. But if one were to stand across the gate such that the highway is not in any meaningful sense obstructed, and people can come and go as they like moving along the pavement, and the restriction simply amounts to them being able to go through the gate so that they can approach the front door at the end of a private footpath, we would submit that that cannot be said to be a meaningful obstruction of the public highway or of any public rights. And the fact that the person who is blocking the gate, who may well be connected with the home, it could be a situation where the person in the home doesn't want to be disturbed or anything of that nature, it could be legitimate reasons for it, but the fact that someone's feet are on the pavement, if what they're doing is blocking access to private premises, to characterise that as an obstruction of the highway rather than an obstruction of the
Now
gate.
you're going to the question of what amounts to an obstruction, but what we're interested in is what amounts to a public right.
Yes, well, in terms of this particular case, we would say that a right of approach to private premises is not a public right. A right to move along a public highway is a public right.
But one doesn't just move along a highway and not leave it at any point. The whole purpose of going along a public highway is to get to your desired destination. And if what you're saying is it's perfectly legitimate to obstruct a public highway to prevent access to private premises, then it's not very useful to have a public right of way along a highway.
I'm grateful for the counter-example. No, that's absolutely not what our position is. Our position is that if one takes a simple example of let's take a high street that has a combination of different buildings, which might include council municipal offices that are undoubtedly public buildings, publicly facing commercial businesses, and then perhaps private businesses and indeed private dwellings. The right to move unobstructed along that road is clearly a public right.
And to get to whatever destination one desires.
Whether it's to the private retail shop or the public council premises.
Yes.
That is a right to move unobstructed.
Yes, that's right. And so the obstruction of a highway would be tautologiously an obstruction of the highway and could also amount to a public nuisance. The point we make is that where the issue that's being dealt with is the right of approach to private business premises, it really depends what's meant by that. Because if all that's meant by it is travelling along a public highway, well, that really, to say that a public nuisance can arise in those circumstances isn't really to take the law any further forward or provide any clarity, because it is clear, and we're not suggesting otherwise, that obstructing the public in moving along a highway is obstructing a public highway. But the way it's phrased in this question, which is to say that there is a public right to approach private business premises, is what I'm seeking to illustrate with the idea of going through a gate and up to a front door or something of that nature. Now, it's not helpful.
Well, you seem to be fencing around, but the question really, the answer to this question, doesn't it depend on the nature of the right that you're exercising when you traverse the private road?
Can I, in a spirit of helpfulness, can I just observe that you're more than halfway through your time now?
Yes, my lord.
We haven't yet looked at a single authority. We haven't looked at the Law Commission report. We haven't been addressed on what might or might not be taken from that report. And the fundamental issue, which we flagged up in advance of the hearing, which essentially is a right derived from a licence, a right of the kind that this legislation is concerned with. We haven't gone into at all. Now, when we rise at the end of this hearing, that's what we're going to be going off and working on.
Yes, ma'am.
And this is your chance to address us on the things we're actually interested in.
Yes, I'm grateful, my lord. Thank you. Well, I'll take that opportunity. In relation to the taking the lead on those points, in relation to the Law Commission's report, we have set out in our case, and I think there's significant overlap, in fact, with the appellants, with the respondents' case in terms of the aspects of the Law Commission's report that have been identified. In my submission, the background to the law of public nuisance in this case that's been provided in terms of the authorities that the court has, the cases of Rimington and PYA quarries, and in relation to the Law Commission's report, don't really give rise to any particular point of contention, and that's why, forgive me, I sought to address it through the Court of Appeal's principles that they sought to draw in this case, because in truth, it's not something that we particularly seek to challenge in terms of the way that the Court of Appeal broadly identified public nuisance, and I don't think there's really a great deal of ground between us and the respondent on it. As far as the Law Commission's report is concerned, there is the section that deals specifically with the change of law of public nuisance, and in relation to the proposals that the Law Commission made in their report on simplification at Chapter 3, the paragraphs that we've identified and which the respondents have also identified, it effectively set out the principle that there's not a significant change in the actus reus of this offence, that what we're really dealing with in terms of the new statutory offence, in terms of a significant change, is a change to the mens rea. And of course that doesn't arise in this particular case. We're not seeking to say that the statutory offence of public nuisance is any narrower in terms of the mens rea than the common law offence was, and we accept that in terms of the subsection we're dealing with, it does follow the line of authorities. As far as the respondents' reference to the cases of Rimington and the case of PYA quarries, again, we accept that the principles that were set out there in terms of the ambit of public nuisance apply. So I hope my Lord will forgive me, but the reason that I've not...
Yeah, but Remington wasn't dealing with the statutory offence, and you have the, it was dealing with a common law offence, which has now been separated out into two distinct subsections. So that's the... So we're needing help, really, as to what the precise scope is of the second subsection that we're concerned with.
And you might want to look at what the Court of Appeal quotes from the Law Commission report at paragraph 12 of its judgment, where the Law Commission talks about interpreting the right, the public right, broadly. The Court of Appeal endorses that. And going back to my Lord's question to you earlier, what we're concerned with is whether a right derived from a licence should be treated, in light of that, as a public right or not. That's what we want help with.
Yes, thank you, my lady. Not seeking to suggest that the law and the public right should be interpreted broadly, we would submit that in relation to the granting of a licence on private premises, that does not fall within rights that may be exercised or enjoyed by the public at large. And it may be helpful, because I touched on it very briefly, but it may be...
Sorry, why do you say that? Because if a private landowner gives a licence to the public to use that land, in a certain sense, the public has a right to use that land. They won't be acting unlawfully if they do so. I think what we're all interested in is what is the meaning, the specific meaning of the word right that may be exercised or enjoyed by the public at large in section 78, 1b2. Is it a right in the narrower sense that no one can ever take that away from the public, in which case whatever rights the public gets through the exercise of a licence that has been granted to them wouldn't qualify? Or is it a right in some broader sense, which might include rights given to the public under a licence?
Yes, I think in application to a road, it might be helpful, and I did touch on it briefly earlier, if we do look at the case of Bowen and Isle of Wight Council, which is at page 431 of the bundle, because in that case, His Honour Judge Kaiser, Queen's Counsel, set out a very thorough review of authorities in relation to what is and is not a road.
It's not the question, as you pointed out, that we're concerned with.
Yes, well, what I was going to say in terms of rights being granted to it is a point that Judge Kaiser identifies from the flow of authorities there relates to circumstances where use of a road is tolerated rather than permitted. And what we're effectively dealing with in this case is a situation where it could be said, due to the flow of traffic on Point and Way and the fact that it's not specifically prevented with physical obstruction in the way that's anticipated in Bowen, is a situation where one has a road where use of it is tolerated rather than permitted. We would say that in relation to use of a road in those circumstances, and it would seem that that's the highest it could be put in relation to Point and Way because of the clear signage on Point and Way saying that it's private property and that there shouldn't be trespassing on it and that CCTV is in operation. If we're in the situation of dealing with it as a situation where it's a road where the public use of it is tolerated rather than permitted, we would say that the reasoning that Judge Kaiser sets out in the case of Bowen and Isle of Wight is such as to lead to a situation where a road, for the purposes, in this particular case, Section 142 of the 1984 Act, can exist for the purposes dealt with in that case, but it's quite clear that a tolerated use of a road does not amount to a public right. Whether a permitted use of a private road amounts to a public right, we would say does not arise on the facts of this case, but in circumstances where a private road is opened effectively to the public so that the public have access to it. Our starting point today was, as I said at the outset, to make a concession of sorts in relation to that and to say that there could be circumstances where an obstruction could take place on a private road that obstructed a public right, but that the public right could not simply be the use of that private road. Because by definition, the use of a private road, for the reasons that my Lord Reid set out earlier, that permission could be withdrawn at any time.
Presumably your clients were trespassers on the road,
yes.
weren't they?
Yes, absolutely. And when one looks at what they were arrested for, all but one of them were arrested for criminal damage, all but one of them were arrested for aggravated trespass, and all but one of them were arrested for Section 241. And so the potential offences that we set out in our case as being applicable in these circumstances, in particular of aggravated trespass, all apply. And the point the respondents make in that regard, in terms of our case amounting to there being no crime committed, that's absolutely not the way we put the case forward. They were trespassing at the point where they committed this. 5 of the 6 were arrested for aggravated trespass, and they were in fact charged with public nuisance within the 6 months. So they could have been charged with the offence of aggravated trespass.
But is that because they weren't using the road to move to and fro on the road?
Forgive me, my lord, is that why they weren't?
Were they trespassers because they weren't using the road within the scope of whatever permission may have been given by the landowner? In other words, you could have permission to people, the public, to move to and fro on the road, even though it's a private road, but your clients weren't seeking to do that. They were doing other things. Is it that they were doing other things that made them trespassers? Why do you say they were trespassers?
Well, our starting point would be that it's private land which they had no express or implied licence to be on. And so in terms of the warnings that are set out on Point and Way in terms of trespassing, there's no exception that would apply to them in terms of them being there. In terms of whether it was an offence of aggravated trespass thereafter, the distinction we draw between their activities and other people who might use the road without permission is, of course, they would arguably have a case to answer in relation to Section 68, 1B of obstructing lawful activity through what they were doing. And so we would say anyone on Pinington Way would be trespassing unless they had an express or implied permission to be there.
And you say that the implied permission is only to go to a business on the premises and not just to use it because you want to go for a walk, do you?
Yes. Yes, and we say that that's the clear intention of the signs on the road, is to make it clear that these are not roads that are intended for use by the general public. And
even if just walking along the road were tolerated, it wouldn't become a permission or a licence.
Yes, exactly, and this is why we draw the distinction with the Bowen and Isle of Wight case, is because in circumstances where the legal position might not be strictly enforced by the landowner, that doesn't amount to them granting a right to people who do it. It's simply a toleration. I think it may be useful as well to deal with an aspect of the various authorities that the respondents have placed before the court, but I'm going to focus on the chapter of Winfield and Jollovich on tort. There are a number of authorities, in particular learned articles, dealing with the tort of public nuisance. We would question the extent to which these would be of assistance to the court.
Well, I'm wondering, because one tends to think of public nuisance as being a rather special kind of tort, actionable on proof of special damage, or otherwise actionable at the suit of the Attorney General. But if one adopts a broad meaning, there will be a private tort simultaneously with the public nuisance, won't there? Because there'll be a what constitutes a public nuisance vis-a-vis members of the public wanting to use Poynton Way, for example, would be an ordinary tort of trespass, I suppose, or nuisance vis-a-vis in relation to the private interest affected by it.
Yes.
I mean, Muller would have a right of action, I suppose.
Yes, exactly. And taking that as the starting point, that again illustrates the position we're in as to the focus of the case being Muller rather than I believe it's Aviva who the owners appointed away themselves. But in terms of any tortious damage done to the owner of the roads, there clearly isn't any, and there was no evidence in the prosecution's case at trial as to any harm, inconvenience or damage done to the owner of the road, because of course the obstruction to that corner of the road is so minor and doesn't prevent the flow of traffic along it. All of the evidence at trial was called in relation to the financial loss to Muller and the inconvenience to staff members of Muller. So it would be very much Muller who would have a private claim.
But in terms of your suggestion that the tort is irrelevant, I don't accept that at the moment, if we're concerned with the common law, because in Remington, Lord Bingham said that causing a public nuisance has been treated as both a crime and a tort, the ingredients of each being the same.
Yeah.
So insofar as the common law is relevant, it's relevant to look at tort cases as well as criminal cases.
Yes. My Lord, I was in fact about to go to exactly that, but in the way that it's interpreted in Winfield and Jollovich, which is at page 1222 of the bundle. And there they identify Lord Bingham's comment in Remington that a public nuisance is act or omission which endangers the life, health, property or comfort of the public or obstructs the public in the exercise or enjoyment of rights common to all Her Majesty's subjects, and go on to identify that the conduct must materially affect the reasonable comfort and convenience of life of a class of the public who come within the sphere or neighbourhood of its operation, and then raise the question as to whether the number of persons affected is sufficient to constitute a class in one of fact in every case. And there's other writing, I believe it's the article by F.H. Newark that makes the observation that the common questions that come up in relation to that category of public nuisance, where one's dealing with an affected class, is how many people it needs to be before it becomes an affected class. The observation here, it says this requirement does not apply to the second type of case identified by Lord Bingham, so that interference with a right enjoyed by the public generally is a public nuisance no matter how many people are affected. And they observe that obstruction of a highway is a public nuisance, for example, even if the highway is a footpath used by only one or two people. And it comes back to the point that we raised a little earlier in terms of the unambiguous nature of obstruction of a highway in that way. The authors of Winfield and Jolovich go on to note, public nuisance is a vague concept which, it has rightly been said, covers a multitude of sins, great and small. The common law crime of public nuisance encompass such diverse activities as carrying on offensive trade, keeping a disorderly house, selling food unfit for human consumption, obstructing public highways and throwing fireworks about in the street. The vagueness of the common law crime led in 2022 to its replacement by a statutory offence, albeit of similar scope. According to the relevant legislation, the abolition of the common law crime does not affect the civil liability of any person for the tort of public nuisance. And so it is clear that that link remains. But we would submit that, bearing in mind the nature of the crime effectively taking the tort forward, and again in the boundaries of nuisance, the F.H. Newark article, the observation is made there that it's the crime of public nuisance that tends to dictate what the tort of public nuisance comprises. We would submit that in logical terms to look at any further analysis of the tort of public nuisance when trying to construe what the crime of public nuisance should entail is not going to be terribly fruitful in terms of what Parliament intended when passing the 2022 Act. But remaining within the Winfield and Jolovich chapter, if we could look at the section 4 highways at page 1225 of the bundle. And under A, actionable obstructions, it's noted that not every obstacle on the highway constitutes an actionable nuisance, for the highway would scarcely be usable if it were. The law requires of users of the highway a certain amount of give and take, and each person is deemed to assume the normal risks of passage along the highway by way of inconvenience and even danger. It's only when the defendant does something which in the circumstances is unreasonable that it becomes actionable. And it gives examples, and at the end of that paragraph, the observation of temporary obstruction, provided it is reasonable in amount and duration, is permissible, nor is every permanent obstruction a nuisance. Then at B below, access to and from the highway, we come to the issue that we were dealing with in terms of impeding access to the highway. So it's clear that the right of passage along the highway is a public right, and that interference with it is remediable by an action for public, not private nuisance, as we have seen. Goes on to say, however, the owner of property adjoining the highway has a common law right of access to the highway, which is a private right remediable by an action of private nuisance, so that anything which prevents his access, as opposed to making it less convenient for his purpose, enables the recovery of at least nominal damages. Any tension between the private right of access and the public right of passage is resolved in the ordinary principle that a reasonable exercise of both must be allowed. And then goes on to address impeding access to business premises. And there's reference to some cases where the claimant's complaint has been that his access to and from the highway has been impeded such that the obstruction has prevented other people coming onto his premises and doing business with him, which seems to get to the heart of what we're addressing in this case. And it says, it seems that such a state of affairs is both a private and public nuisance, though as far as the latter is concerned, the loss of trade will amount to special damage. And so it's clear that in circumstances where there is an obstruction of a highway that impedes access to a business premises, there can be a tortious claim in relation to loss as a result of that obstruction of the highway. But whether that amounts to a public nuisance from a criminal perspective, we would say is a different matter, because there is a degree of ambiguity there. And the case that's footnoted in relation to that is Wilkes and Hungerford Market, and it's an 1835 case. And so it's quite clear that where you've got an obstruction of the highway that does give rise to financial loss by business due to people not being able to access that business, then it is, according to Winfield and Jollovich, a private and a public nuisance in tort. But this all works on the basis of it being access to and from the public highway. What it doesn't address is a situation where one's dealing with a private road.
In that sort of situation, one would normally have servitude rights of access, which would entitle the business premises user to have access along the road, and that would include those with legitimate purposes to visit
Yes.
the business.
Yes. But again, we then come back to the certified question and the issue of whether or not those rights that users of the business premises have to access the business. So if we take the simple example of suppliers and customers of the Muller site, whether or not the rights that they enjoy in that sense are rights that can be exercised and enjoyed by the public at large. And we would say that it's quite clear that they're not, because by definition what's been done is those rights have been granted to a particular subsection. And so it comes down to this fundamental distinction in the statute between the section of the public to be affected and the rights of the public at large. So clearly a section of the public in those circumstances have rights of access, and a section of the public in those circumstances have the right to approach on a private road to private business premises. But it is clearly not the public at large that have that right, and that's why in Winfield and Jollovich, where this right to tortious damages is set out, it is done explicitly in the context of an obstruction of the highway, where there is that unambiguous situation where, even if it's only done by one or two people, it still amounts to public nuisance.
Something that Lord Bingham emphasised in Rimington was the need for criminal law to be clear. He focused on Article 7 of the European Convention, but one might equally just say it's a domestic principle of statutory interpretation. In this case, obviously, Article 10 of the Convention is relevant, and prescribed by law is one of the requirements.
Yes. In terms of whether or not there'd be Article 10 rights engaged if they'd been obstructing the highway, one can imagine that we would get into very different territory in terms of the proportionality prosecution if it had been...
Well, you're missing the point.
Sorry.
All I'm raising with you is that you might pray and aid the principle that criminal legislation ought to be construed in favour of the subject rather than in favour of the Crown, where it is reasonably open to more than one interpretation.
I'm grateful, my Lord, and I would indeed do that. If I can take the point further a little by illustrating what we say is the failure of the way the law is left by the Court of Appeal in terms of it being too open and too vague and effectively going too far in terms of the expansion of what is meant by rights. The situation in this case, and if my Lord will give me one moment, I'll just bring up a note. So it essentially comes back to what the points that we made briefly earlier about the fourth and fifth principles in terms of the lack of a de minimis principle and the suggestion that it's an offence that could be committed even when there is a obstruction when nobody's actually obstructed. But we would say that the difficulty focusing on the certified question in this case, an issue we're dealing with in terms of the degree of latitude that would be given in the future, is that if one takes the approach that rights exercisable and enjoyable by the public at all, by the general public, include rights of this nature, where it extends to private property, it relies upon permissions being granted, it relies upon circumstances in which permissions can be given and rescinded, it relies upon circumstances where there could be ambiguity both in the minds of potential defendants and indeed in terms of the police as to whether or not a particular permission or a particular tolerance existed at any particular time. It does all lead to a situation where the position would be intolerably unclear as to where the boundaries of public nuisance are. And the virtue that is afforded by answering the certified question in the negative is that it does make it clear that the offence of public nuisance will continue to focus on what can properly be regarded as public rights rather than private rights. And we say that, and I've already touched upon this, in circumstances where Parliament has simultaneously legislated in other ways to create offences that would also deal with circumstances not caught by public nuisance, where things were taking place in the private domain. And I repeat the observation that the defendants in this case, we would say, were appropriately arrested for offences that relate to crimes that could at that point be committed on private premises in terms of aggravated trespass, the Tula offence and criminal damage. But added to that, in terms of the way that this court would look at it going forward, we've also drawn attention to the further offences that have now come onto the statute book as a result of the Public Order Act 2023 in terms of locking on, going equipped for locking on, and interference with public infrastructure, with national infrastructure. And so there's a plethora of offences that potentially apply in circumstances where conduct of this kind takes place on private property. This isn't a situation in which to say that criminal conduct that takes place on private land would go unpunished and that there would be no sanction. It's simply to say that to extend public nuisance into this domain runs the risk of doing what's been identified as a risk going right back to Remington of the boundaries of public nuisance becoming too broad. And we submit that Parliament would not have simultaneously legislated in the way it has in creating offences such as locking on or interference with national infrastructure if Parliament's intention had been that those offences would simply be subsumed underneath public nuisance and that the prosecution authorities could simply charge public nuisance in every offence as a broader offence that catches all.
I see that the principle of strict interpretation of criminal statutes applies with particular force where they impose, well, the penalty involves deprivation of liberty. Here we're dealing with an offence with a maximum sentence of 10 years imprisonment, I think?
Yes, exactly, and significantly more than the other offences that we're talking about. And it is an issue that potentially arises where you have, and the Law Commission, as my lords will note, did consider whether or not there ought to be anything specifically said in relation to a requirement that where there is a more specific statutory offence that applies, that should be charged. And the suggestion in the Law Commission's paper was that the Crown Prosecution Service should consider issuing guidance to that effect. Because, of course, prior to that, the law post-Remington was that there should, where a statutory offence existed, ordinarily be a charge under that statutory offence rather than public nuisance. And so the suggestion was that even after the statutory offence of public nuisance comes in, it would be at least desirable for that to be the position. Now, that's not where we are, in that the statute doesn't make any requirement that where there is a specific statutory offence that more particularly covers the conduct, that should be charged. But nonetheless, it does illustrate that Parliament had this in mind, that these other more specific, often summary-only offences have been brought in through legislation both at the same time and subsequently to enable more particular charging in those circumstances. And so it is clear that Parliament was not passing this offence of public nuisance in such a way as to broaden the ambit of public nuisance beyond where it had been previously under the common law offence. And we would submit, again, recognising the way that the Law Commission put forward the proposal, adopting what had been the description of the offence in Archbold, but adding to it the mens rea aspect, that's really the critical change that was made by the 2022 Act, was neither to widen or narrow the ambit, but simply to add the mens rea.
Well, I would have thought the significant change was to require serious harm rather than something that was disruption of somebody's comfort.
Yes, forgive me, my lord, I was focusing on the second limb. I agree entirely.
You have been asked this, but can I ask you again, what do you say about what the Law Commission said at paragraph 3.45 of its report, which is set out in paragraph 12 of the Court of Appeal's judgment?
Yes, well, forgive me, I think all I said when this point was raised previously, and I apologise for not going into more detail, was that we wouldn't seek to say that the rights of the public shouldn't be interpreted broadly. But I think taking the example that's given there as a good way of illustrating it, because the example that's given at the end of 345 is the case of the person who interrupted a boat race by jumping into the Thames, and there's a note of doubt being expressed in relation to that. Now, that case, to give it its full name, the Crown and Oldfield, was an incident in 2012 when a protester of sorts jumped into the River Thames and swam into the path of the boats in the middle of the boat race, causing it to be interrupted before it was resumed, and was taken from the water and arrested and prosecuted for public nuisance. And the nuisance in that case was said to be the obstruction of the public's right to enjoy the boat race. So it wasn't an obstruction of the Thames, it wasn't an obstruction of the rowers, it was an obstruction of the general public's right to enjoy the race. And effectively, circumstances in which you've got a national institution of a sporting event in terms of the Oxford-Cambridge boat race being brought to a halt for the first time in its history. And those were the circumstances in which Mr. Oldfield was prosecuted for public nuisance.
Well, that could now be said to come under Part 1, couldn't it?
Yes, I think that's right, my lord. I think that's right. Because in
the
those
Law Commission cite authorities giving examples of rights of the public being interpreted broadly in relation to the common law offence?
Yes, in the charts that they give of the different examples.
I'm sorry, in the...
Forgive me, I'm just making sure that I'm following my Lord Donnelly's reference. There's a table that the Law Commission included.
Can you give us a page number?
No, I'm not sure if we're talking about the same thing. Forgive me.
Examples of a public right being interpreted broadly.
Yes,
Yes.
They say in the existing offence the reference is interpreted broadly. What authority is there to vouch that proposition? That's really what we're asking. That's really what we've been asking since 10:30.
Yes, I'm sorry, my Lord. I think the only answer I can give to my Lord's question is that we're not immediately aware of an authority that does support the proposition that the right should be interpreted broadly. And so it may well be that, again, we've been too generous with that concession and that they, as a point of principle, they shouldn't be interpreted broadly. I think the position that we come to on this appeal is essentially to draw a delineation between public and private rights. And so, in essence, we've not taken a particular position in terms of how broadly public rights should be interpreted within what can be considered a wholly public sphere, because our focus has been on rights in relation to private property. But as a point of principle, I can't provide an authority to support that. And it may be that we shouldn't have conceded that the Law Commission were right to suggest that, or that the Court of Appeal were right to endorse it. The point I was seeking to make in terms of expanding upon the boat race case as a contentious example is that, again, what we have is a situation where the Crown in evidence in that trial relied upon the viewing figures for the boat race on television to illustrate the extent to which it was a publicly enjoyed experience, and the fact that it was on free-to-air BBC broadcast, and so it was interrupting a sporting event that was being broadcast for free to the entire country. And that's a distinction that we would again draw as being a stark contrast with the kind of situations we're dealing with in this case.
And sorry, have you given us that Oldfield?
Yes, I'm so sorry, my lady. I was defence counsel in Oldfield, which is why I know so much about it. It's not a reported decision. Mr. Oldfield was sentenced to 6 months imprisonment and did not appeal either his conviction or sentence. So
maybe before this offence was created, there wasn't a very clear distinction drawn between what is now being put into Limb 1 and what's been put into Limb 2. But now that we've got that distinction, it's easy to bring the boat race case within Limb 1, isn't it? On the basis that it's a serious annoyance when millions of people have the spectacle interrupted. And also within Limb 2 on the basis that there's a public right to use the river which is being obstructed.
Yes, there's clear overlap.
Those are two different arguments.
Yes.
And they shouldn't be muddled.
No, I simply make reference to that because that's identified in the Law Commission report as being a potentially contentious example of a situation where the definition and the right should be interpreted broadly. And in essence, taking that as an example of a situation where it's said that the right has been interpreted too broadly, it is nonetheless still, whatever one may think of the right, a right that was, on the Crown's case, being exercised by a very sizable proportion of the UK population at the time. So it's... Well,
if causing interference or annoyance to the public generally is within Limb 2, that rather collapses the distinction between Limbs 1 and 2, doesn't it? Everything then comes within Limb 2 and you don't even have to show it's serious.
Yes, I take my Lord's point. Yes. My Lords, I'm aware that I'm coming to the end of the time I have. The remaining points that I would have sought to make was simply to deal specifically with a number of points that arise in the respondent's case, but it may be that's not the most useful use of my time. Is there anything else that I can...
Well, you've got another quarter of an hour.
Yes. Yes. But before I spend that quarter of an hour, essentially. Because otherwise I'll address the three submissions that the respondents have made in their written case, which is what I was proposing to do. So the respondents identify three limbs of their submission. The first one identifies at their paragraph 42 that the decision of the Court of Appeal was based squarely on the obstruction of point and way, and we've already identified that that's not the way the case was put, and nor does the certified question specifically deal with access to point and way, although I do accept that in the approach aspect of it, it can be interpreted in that way. But we continue to rely on the distinction between count 1 and count 2 on the trial indictment as illustrating the difference between an allegation of what we would submit would be a de minimis obstruction of the road in any event on point and way, bearing in mind that the Crown never sought to put their case on those terms, and it's understandable why, because the road wasn't really obstructed in any meaningful way, save for the obstruction of access to the Muller site, which was where the focus was. At paragraph 50 of the respondent's case, they argue that the implication of our case is to put us in a third liminal region in which the appellants were neither trespassing on the Muller production site nor impeding the right of the general public to go to and away from it. But as I've made clear, we would say that the appellants in this case were trespassing. They were trespassing on the privately owned road of point and way, and that's why we've always said in this case, and we said in our written case, that the offence of aggravated trespass could potentially have been appropriate in these circumstances. And that really goes to the nub of this issue in terms of whether or not there's any need for public nuisance to cover private property in circumstances where the offence of aggravated trespass is already, to a significant extent, serving that function of dealing with obstructions that take place on private property. The Crown's
Do we have that offence in the bundle?
Yes.
To see what its requirements are?
Yes. It is at page 217 of the bundle, my lord.
Thank you.
And just to be clear, in terms of the offences that we've made reference to throughout this hearing, we've got aggravated trespass at page 217. We've got the new offence of locking on under the Public Order Act 2023 at page 370, the offence of going equipped for locking on at page 372, the offence of interference with use or operation of key national infrastructure at page 373, and then the offence of intimidation or annoyance by violence or otherwise under section 241 of the Trade Union Labour Relations Consolidation Act 1992 at 376. So there's the run through those pages of the bundle of the various examples. And we'd also, in that context, draw attention to the case we referred to in our case, which is at page 402 of DPP and Bailey, a 2022 case, where in circumstances almost identical to these, to the extent that it was the same campaign group, the defendants participated in a protest that was charged under section 68 of the Criminal Justice and Public Order Act 1994, aggravated trespass, and the divisional court in that case dealt with an issue that doesn't need to trouble this court in terms of the mens rea of aggravated trespass. But we refer to the case simply to illustrate and virtually identical demonstration to this that was charged as an aggravated trespass.
Well, that's just a prosecution choice, so isn't it? It doesn't really tell us anything.
No, but I agree, my lord, but the respondents in their written case do suggest that our case would leave no offence committed by the conduct that took place in this case. The second submission the Crown make is at their paragraph 43 to submit that the alleged obstruction of point and way was plainly an interference with rights that may be exercised or enjoyed by the public at large. As I've said, we don't accept that for reasons that we've explored. And the third submission that they make from their paragraph 44 and 57 onwards is that the general public does ordinarily have a right of egress from private premises. And although this is a small point, it's one I haven't actually touched on so far in our submissions this morning, and it does relate directly to the certified question. And so I think it's important that I do before we finish, which is that our focus in our written case initially, based on the way that the case had originally been put, was on this finding that it is a right exercised and enjoyed by the public at large to leave private premises. And as I say, that was initially the focus of our written case. We maintain our position on that, and I know that the respondents maintain, albeit they say it's not determinative of the appeal, and they maintain their position that it is a right, and the Court of Appeal were right to find that it's a right exercised or enjoyed by the public at large to leave private premises. Our position on that can be stated very, very simply, which is that clearly anyone within private premises cannot be prevented from leaving. It would be an offence of false imprisonment to detain someone in private premises. So we're not suggesting for a second that any individual in private premises does not have an individual right to leave. But to say that in relation to any particular private premises, the general public have a right to leave, would have the unforeseen conclusions of, for instance, meaning that those premises couldn't be secured on the basis that anyone who happened to be in them would have a right to leave them. It's clearly not a right enjoyed and exercised by the public at large.
I don't see that follows. So I don't see that it follows that you wouldn't have a right to leave even though the egress was controlled.
Well, suppose you're a trespasser and you climbed over the fence to get in. Would you have a right to leave?
I think that's a different matter in that someone, it would really depend on whether or not any offences have been committed. But on taking it plainly on the face of the question, someone climbs over a fence and is trespassing. We would say they have a right to leave in as much as they couldn't be lawfully prevented from leaving if all they had done was trespass. So if a child comes into a garden to get a football, the owner of that house couldn't lawfully prevent that child from then leaving again. But in terms of whether it's a right enjoyed by the public at large, it's clearly not the case that the owner of a property has to leave their front gate unlocked in case a child climbs into their property and retrieves a football and then wants to leave. And so that's probably how we'd illustrate it. But it may be that this all seems rather spurious compared to the main issues that we're dealing with. But we would firmly maintain that those employees and all other persons involved in the business of Muller who were on the site on the 8th of September had a right to leave individually as private citizens, but the right to leave that particular site was not a right that was exercised or enjoyed by the public at large. And so we would say that in that aspect of the certified question, the respondents having essentially conceded that entry isn't a right enjoyed by the public at large, we would submit that egress similarly isn't a right enjoyed by the public at large, and that the court's only real focus should be on the approach issue to the extent that it relates to the road. Can I be of any further assistance?
No, I think not. Thank you very much, Mr. Newton. Yes, Mr. Perry.
Thank you very much, my lord and my lady. My lord, may I make our position clear at the outset? Our first submission is that a general right granted to pass along a private road, such as Point and Way, is a right that falls within the scope of Section 78B12 as a right that may be exercised or enjoyed by the public at large. That is consistent with the approach adopted by the Law Commission in its consultation paper and in its final report. And we would submit that it is at the core of the rationale for the criminal offence. And I'm going to come on and look at the offence and how it developed in a moment, but I am going to address some of the points that have been made in the course of argument this morning. And may I just deal with, for example, the question is there an authority that says there's an unqualified right subject to a bag search or anything of that nature, such as was suggested by the Court of Appeal in this case? Lord, so far as I'm aware, there is no such authority. And your Lordship also raised the question of Ong, the football stadium case. It was a conspiracy case. It wasn't actually one where the lights did go out. Lord Bingham addressed it in the Rimington decision. And clearly, of course, when Lord Bingham was addressing it, as your Lordship noted a moment ago, at common law, it wasn't so necessary to decide whether you're a Lim 1 case or a Lim 2 case. That may explain, although some of the public tort cases suggest that there may be a more flexible approach to rights. Some of those early Victorian cases are impeding access to booksellers in the City of London in the 1830s. And what we would submit, and I'll explain why there is a difference between Lim 1 and Lim 2 and how it doesn't all collapse into Lim 2. And I'm also going to address why the presumption that might otherwise be applicable in criminal cases against doubtful penalisation has no particular force in this case, for the simple reason that Section 78 is a single offence that can be committed in a number of ways. So it's not really a question of it's doubtful whether you've committed a criminal offence. It's just what form of public nuisance have you committed. So what I'm going to suggest, for example, is if there could be no objection in a case such as this to say count 1, Lim 1, count 2, Lim 2, and leave it to the jury to decide, because a prosecutor might not know whether points such as, well, what's the status of the land are going to be taken.
But surely each limb would have to satisfy whatever is the relevant standard for clarity of the criminal law.
Yes.
So I think it's being put against you that even though you have to break it down, each limb has to satisfy that criterion, and the relevant limb we're concerned with would not do so unless you construe right narrowly. Well,
my Lord, I'm going to submit that...
Yes, I mean, in fairness, this is not an argument that was made against you.
Yes.
But frankly, it was in my mind.
Yes.
And I think it's best to have it out so you can deal with it.
I respectfully agree, my Lord, and we are, of course, involved in a simplification of the criminal law project. So, so far as that's concerned, but I'm going to turn to the statute in a moment, but I am going to be saying something in due course about the order that your lordships and my lady might make, depending upon the outcome of the appeal, because of course this is an interlocutory appeal where the trial has yet to take place. And as has been observed during the course of argument, it would appear as though there would be no answer to a Lim 1 case, now that we know what the issues are. I'm going to say that the learned judge was respectfully wrong, and he took too narrow a view of the legal position.
But it does make a difference, though, doesn't it? Because Lim 1 would be for the jury, wouldn't it? I mean, they might not have much difficulty, but you couldn't. It has to go to the jury whether there's a serious inconvenience or not.
Yes.
Whereas if you're right on Lim 2, the jury never have to decide that. It doesn't matter how serious or trivial the inconvenience was, as long as it's not perhaps trivial, but as long as it counts as an obstruction, that's good enough.
Yes, and the distinction between the two is that Limb 1 was always considered to be the offence against the offence that created the risk of harm, and the Limb 2 obstruction was the offence that engaged the contravention of a public right in itself, which is why there's a distinction between Limb 1 and Limb 2.
Although now at least under the statute, it's causing or creating a risk, isn't it? Under
Yes.
Limb 1.
Yes, yes.
But it used to be endangering under the common law, is that right?
Yes.
Is that what you're saying? So
Yes. Although your Lordship was also right earlier about the comfort. I mean, part of the process here, and it's why the Law Commission analysed it in the way they did, it's why Lord Bingham analysed it in the way that he did, is until you get to the late Victorian period, where people are concerned about we ought to be putting the criminal law into codes, you start having people who are writing the treatises, the commentators, such as Sir James Fitzjames Stephen. No one is really analysing these cases at the level of principle because everything is a jury question. And there isn't a court of appeal. Well, there is, but there's just the court for Crown cases reserved, and usually the trial judge is sitting on the appeal to confirm his own ruling when there is an appeal. So there isn't the analysis in the authorities that says, oh yes, you can say this is what you have. But what the Law Commission did was to note that the two limbs had become separated in certain Commonwealth provisions, the two limbs that had been identified in Stephen's Digest and also in the Criminal Code, not solely drafted by Mr. Justice Stephen, but also Mr. Justice Blackburn, who features in some of the cases. But what the offence was driving at was that it was an offence against the public and the way they enjoyed public spaces. That's given as part of the rationale for the offence by the Law Commission. And that underpins the Law Commission's analysis of why it was that the concept of a right, such as a licence granted to pass along a road, we would submit, was to be characterised as a right that may be exercised or enjoyed by the public at large. So, for example, I'm going to, if I may just go to...
Sorry, did the Law Commission put it as explicitly as that, or is 3.45 what you're relying on?
3.45, but I'm going to look at the rationale, but my lady, yes. But
so yeah, 3.45.
Yes. May I just... May I just try to sort of give examples? Because my Lord mentioned about toll motorways, and of course you can think of more homely examples, such as Battersea Park or a local park, where they close the gates at night and they open them in the morning. Now, no one has the right to go into the park when it's closed. But when the park is open, members of the public are permitted to use it. Now suppose, just suppose, for the sake of this argument, someone were to glue the gates closed during the middle of the night. But it was discovered before the gates were open. So no inconvenience, no serious harm, but there has been an obstruction of a right that may be enjoyed, exercised or enjoyed by the public. Now, what I would respectfully submit is that is one of the distinctions that you have. They don't actually cover entirely the same ground. And what we would respectfully submit is when the court looks at, obstructs the public or a section of the public in the exercise or enjoyment of a right that may be exercised or enjoyed by the public at large, the draftsman has approached it by distinguishing between the exercise of a right, which we would take to be the active exercise, and the enjoyment of a right, which we would take to be the existence of a right in being, whether you're seeking to exercise it or not, which we would respectfully submit explains the Court of Appeal decision, paragraph 23, of which complaint is made that the Court of Appeal in paragraph 23 said you didn't need to have an obstruction, which is not what the Court of Appeal were actually saying in paragraph 23. What the Court of Appeal said as part of its fifth proposition, it's paragraph 56 of the bundle for the court's note, it's not an essential requirement that the prosecution prove that any person or group of persons in fact tried to exercise or enjoy the relevant right but was unable to do so. There may be evidence of obstruction of a right which may be exercised or enjoyed by the public at large, even though at a particular time no one was trying to do so. So there's a distinction immediately between Lim 1 and Lim 2. And it also, we would submit, highlights the importance attached to a Lim 2 case, because the offence is to the public interest in the freedom to exercise the right when it is available to be exercised. Now,
sorry to interrupt you, Mr. but in terms of distinction between 1 and 2, what I'm interested in is why anybody would ever be charged under 1 if you can always get them under 2.
Well,
because you don't need to show then that anybody's been actually inconvenienced.
The
mere fact that you're in the public space and that you're obstructing somebody who might have wanted to go into, if you count the private road as a public space.
Well, it may be. I mean, I'm not submitting for a moment there isn't a degree of overlap between these cases, and it may be that ultimately there are going to be prosecutorial choices to be made depending upon the evidence. But, my Lord, what I am submitting is that there is a distinction which highlights the difference between the two, and the Law Commission was, we would respectfully submit, right to say that what a right means within the purpose, within the meaning of the section, is not the inalienable right that can't be taken away, exercisable at all times. The example of the park, the concert, and matters of that nature.
Well, what is the distinction? Does it depend on whether it's open to everybody or to all but 2 people? I mean, all but 1 person? Is that why the line comes? Or must it be open to most people? Or,
well,
I mean, what if you say that I'm going to allow onto my property everybody except 2 or 3 people because I object to their presence? As the landowner, I've got a perfect right to exclude them. Well, everybody else is welcome.
Well, my Lord, I'm going to submit that so far as Lim 2 is concerned, that is public events, and I would submit that Ong is a Lim 2 case as opposed to a Lim 1 case. If at a football match there is an interruption to the game, and it was a match that was open to the public, obviously you had to buy your ticket to go there, then I would submit that falls within Lim 2. I also submit, as the Law Commission appeared to submit or contend, that the boat race case wasn't dependent upon the right of navigation on the River Thames, which I accept there would be, as there would be, there's a common law right on all navigable rivers. But the point about the point about the right and why the right of movement and obstruction of the right is so important is because that is at the core of the nuisance cases, and it's also what your Lordship and my Lady may have read, the reconceptualisation of the tort by Professor Nayers, the Canadian, distinguished Canadian academic, who has used the philosophy of an equally distinguished Canadian philosopher to conceptualise the tort and the public nuisance aspect of it as being linked to the ability of civil society actually to engage with itself through commerce, through the ability of individuals to move and not be trapped on land. And that is why we would respectfully submit that, and what Professor Nayers was saying is that this movement, he wasn't talking about this particular point, but what he was saying was this ability to move is at the foundation and core of public nuisance. And in fact, he says the tort should be scaled back to accommodate only the right of passage and also to fish on the foreshore. As he says, historically, they were the two fundamental rights: one, to enable people to engage with each other socially and commercially. A polite and commercial people had to be on the move. They couldn't be trapped on their land. And equally, that's what we're dealing with here. And my learned friend says, there's no problem here, aggravated trespass. Well, with respect to my learned friend, there is a problem, because immediately there's incoherence between this case and the Count 2 case, which went to trial and led to a conviction. Because the appellant, who didn't make a submission of no case to answer, was convicted, presumably on the basis that there was a right of access along point and way within the meaning of Section 78. And we would submit that it would be incoherent, first, to say there was a public nuisance further down point and way, but not outside the site.
Well, and clearly it would be. Yeah. So either he missed the point, or these people should lose.
Well, my Lord, what we would submit is that...
That's why I was asking Mr. Newton how far away from the gate you had to be on the road in order to count for his purpose. I mean, either the private road is not subject to public rights, or it is.
Yes. Well, my Lord, it has a broader public interest element, however, that would arise, because suppose, for example, I'm going to be making submissions about the order that we would invite the court to make in this appeal in due course. But just suppose, I'm advancing this just for hypothetical purposes, but just suppose your Lordships and my Lady did decide actually it's a right in its full-blown meaning. The Law Commission missed the point. the statute has to be scaled back, and there has to be some content given to Limb 1 and Limb 2. Suppose that's the outcome. Presumably, there would have to be an appeal in that other case, possibly out of time or possibly through the Criminal Cases Review Commission, because it would be inconsistent with anything that your Lordships and my lady had said. However, everyone may be agreed that however you look at this, in this particular case, the offence would be made out on these facts, because if it's not Limb 2, it's certainly Limb 1, but that would be a matter for the jury. But there is to be a jury trial in this case. So what I would be...
Sorry, there has been a jury trial. It's just that there was a ruling of no case to answer at half-time.
Yes, and then...
So if it were the case that you thought this was, in the alternative, a Limb 1 case, then the prosecution should have run that and argued that the ruling could only be made in relation to Limb 2, but not in relation to Limb 1, and the case would have gone to the jury on Limb 1. I don't see how you can have it over again.
Well, lady, the trial, the jury were discharged.
Because there was only an argument based on Limb 2.
Yes, and then and there's a retrial scheduled.
Well, that's subject to a Limb 2 argument.
Well, but...
Well, is it
there'd have to be an application to amend the indictment, wouldn't there? And then that would be dealt with in that way.
Yes.
But surely that would be dealt with by the criminal court. That's not for us.
Yes,
not for us.
Yes. But the reason I raise it is because it may influence the order made by the court on the appeal. And may I just try to explain why? The position is that the options open to the court on an interlocutory appeal are either to confirm, vary or reverse the order of the courts below. But if you were to confirm the ruling of the judge, the ordinary effect of that would be not guilty verdicts. But if you were to vary the order, that the trial was to take place subject to any application to amend the indictment and in accordance with the ruling of this court, the decision of this court, then the trial could nevertheless proceed, but it would be open to the prosecution and the court to proceed on an amended indictment. So the point I'm making, my Lord, is really this, that ordinarily on a preparatory, on an interlocutory appeal where there's been a finding of no case to answer, the ordinary rule would be, well, the not guilty verdict stands, but that's not necessarily the invariable rule, because if the court felt actually there was scope for a fair trial to take place on the basis of an amended indictment, then that would be an option available to the court. But I simply mention that because it may be relevant.
And the difficulty is that if we have to take the indictment as it is.
Yes. Yes.
If we think that the judge was right to rule that there was no case to answer on the indictment, it's difficult for us to fix a trial on the basis that there may be an application to amend the indictment. Well,
my Lord,
that's what you're inviting us to do.
Well, the statute says you can confirm, vary, or reverse. Now, vary must envisage, the draftsman must have envisaged that you could vary it, because the statute doesn't say the court must reach such a conclusion.
But one would only go down that road if this court was told that there was a real prospect of that motion being made. Why else would...
Well, my Lord, all I'm saying is that it highlights, I would respectfully submit, the narrowness of the argument, because it appears during the course of argument to have been suggested that the facts here do fall, at the very least, within Limb 1, but I'm going to submit that that they fall within Limb 2, and I'm going to, if I may, I'm going to turn to the Law Commission report. I know that the court will be very familiar with it. The Law Commission looked in detail at the offence in its 2010 consultation paper. And may I just give the court, or perhaps I can just turn to it, but it's at page 1074 of the 2010 Law Commission paper, which was obviously the members of the Commission at that time were different from in 2015, but they were considering the same issues. And in 1074 of the bundles, the court will see that this is in Part 6, restating the offence in statute. And at 6.7, the Commission considered that it would be preferable to explore alternative definitions, but then went on to say that the purpose of the definition would be to preserve the requirement of common injury, which of course is what Lord Bingham had said was the core concept that lay at the heart of the offence, while keeping the scope of the act or omission causing the injury as wide as possible. So there was to be this, a broad, flexible offence, and the Law Commission had rejected some of the criticisms that had been made of the offence by Professor Spencer in his Cambridge Law Journal article. And in the later report, the position in relation to the law as it stood was in Part 2, Chapter 2, at 921. And the purpose of taking the court to this is just to make good the point that there wasn't the Limb 1, Limb 2 distinction, and you don't find that in the authorities. What you do find in the authorities is the question of whether there's the necessary indiscriminate widespread effect, such as the Court of Appeal were looking for in the PYA Quarries case. And the court will also note that the ONG, the football floodlights case, is mentioned at 922. It had been mentioned by Lord Bingham also at 2.3, but it's used as an example simply of a nuisance involving a single act. And there's a discussion about the current law, which goes on to 35 at 9:30 when they go on to discuss outraging public decency. Then in their analysis, if I may just very quickly and briefly deal with part 3, which is where they deal with the options for reform, and that begins at 9:40. And I'm not going to deal with it in detail, but just so that your lordships and my lady know where the relevant parts are. 3.12 is the Law Commission stated rationale, and one question is the nature of the right or interest which public nuisance seeks to protect. Its proper use is to protect the rights of the public to enjoy public spaces and use public rights such as right-of-way without danger, interference or annoyance, thus preserving the analogy with private nuisance, which gives similar protection to the right of individuals to the reasonable enjoyment of their property, and some support from Rimington, and also the requirement of certainty. They deal with the overlap of offences, and there's the table to which my learned friend has invited the court's attention, and they nevertheless consider that the basis for an offence is made out, and then they deal with the scope of the offence at 954, and this is where at 336 they say they prefer the Archbold definition, with the two alternatives must be either to endanger the life, health, property or comfort of the public, or to obstruct them in the exercise of public rights. And they go on to say the earlier definitions make the two conditions cumulative. This is a defensible approach, but depends on interpreting the reference to rights broadly as including not only enforceable rights such as public rights of way, but also the general right of the public to enjoy public spaces without danger, interference or annoyance. The Archbold formulation puts it beyond doubt that these cases are included in the offence, whether the reference to rights in the second limb is interpreted broadly or narrowly. And then they return to the limb in 345, where they address expressly the obstruction of the public in the exercise or enjoyment of rights common to all Her Majesty's subjects, which had been the expression which had been used in the Victorian Code and in some of the Commonwealth, or by Stephen in his code, and sometimes in the books. The reference to obstruction of the right is interpreted broadly to include the general right of the public to go about its business without interference or annoyance. It's not confined to specific and enforceable rights, such as a right of way. If similar wording is used in the definition of the new offence, it should be interpreted equally broadly. For example, the offence should cover the case of the person who interrupted the boat race by jumping into the Thames. So they are making the point about the offence should be interpreted, rights should be interpreted broadly. And what the Law Commission had in mind was the general right of the public to go about its business without interference or annoyance. So that would cover the park, the people who go to shopping precincts, going about your daily business, which we would submit is what is catered for by the offence.
Would it cover a right derived from a licence?
Yes. Yes.
You say it would.
Yes. The right, the licence in this way of for the general public to use point and way is about as close to the Law Commission's analysis as you could get, because you've got a licence. It's not like the Isle of Wight case where a road, for the purposes of the road traffic legislation, is simply a road to which the public has access, trespasser or no. This is a licence which is a legal entitlement to be there, and it looks as though it's open to the public at large. And
the thing is, this requires somebody reading the statute to read the word right and think, oh, well, that includes cases where I don't have a right, but I'm just permitted to go onto the property. And that doesn't seem a very likely reaction, because most people understand the difference between private roads and public roads. But even if it were a possible one, it's at the very least ambiguous, isn't it?
Well, my Lord, your Lordships and my Lady can now make it clear, as the Law Commission made it clear. I remember once Lord Hoffman saying to me when I was advancing an Article 7 argument, "Don't worry about that, we'll put it right." So I'd make the same. I'd make the same point to your Lordships.
But surely the argument you have to face there on that is, before we get to the stage of us making it clear, if the statute itself is unclear, then doesn't the principle of doubtful penalisation apply at that stage?
Well, my Lord, I would submit not, because the Law Commission report is an aid to interpretation.
Well,
is it?
Perhaps that's the point at which we might adjourn.
Yes,
you can think about that proposition.
I look forward to dealing with that point at 2:00. Thank you very much, my Lord. Thank you.
Well, we'll look forward to hearing you on that at 2:00.